Welcome to the second video in our video series. In this video, we're going to be breaking down the language of the abortion amendment. This is so important to understand because this amendment is going to become the law of the land in Virginia. This would make abortion a fundamental right, meaning it cannot be infringed upon or affected in any way. And this is really concerning to not just pro-life people, but to pro-choice people. So it's important that even though it's complicated, we understand what this amendment means and we're able to talk about it in an educated way with other Virginia voters. We're also going to look at the language of the ballot question because the question that people will see when they go to vote is not reflective of what this amendment really does. And so we want people to understand that there's a difference between what you're being presented with that you're voting on and what would actually go into the law. And so you need to be informed about what those differences are and how we can talk to people about them. So let's get into this. So the first thing to understand is that this is an amendment to Virginia's Constitution, and that means we would be introducing into our Article 1 Bill of Rights a fundamental right to reproductive freedom, which in this case really means abortion. There are other things included on that list, but we know that what this would really affect is abortion laws in Virginia. And this would go beyond Virginia's current abortion law. This is much more extreme. This is creating, a no holds, no any restrictions, no regulations, not even in the interest of the health and safety of the mother. This is complete freedom for the abortion industry to set their own rules, to do whatever they want, and would make Virginia a safe haven for abortion past the point of viability. And so we want people to understand exactly what the language in this amendment means, and we're going to dive into that.
So the first part we have here, we know there's a lot of words, but we really wanted to highlight the words that stick out that are the most important when talking about this amendment. So here it says every individual has the fundamental right to reproductive freedom. So the concerning factor of this is that age is not specified here. That means any individual at any age. So what this will imply and potentially mean is that minors could seek abortions, negating the need for parental consent. So when we are talking with families or parents, we can talk about that. The concern is if something is happening to your daughter and they need to get an abortion, you may not be aware of what they'll be doing, or you may not be aware of what led to them needing to get an abortion, which we know we saw already happened in Fairfax last year, where there were claims that there were several students that were encouraged or coerced by the social worker to get abortions without parental knowledge. And then the bottom here is they list out all of the different types of reproductive care that this amendment will include, but we really want to focus on abortion care because that's what the heart of this amendment is about. And what this means is that there'll be abortion throughout all 3 trimesters. And like Thomas said earlier, abortion for babies that are past viability. So this might involve the babies that are born alive, might also not be getting care that they need. And when we'll go more into as well about the conditions that would require a later abortion and how those will also be reduced for individuals to get abortions in later trimesters.
Yeah, I'd say next we want to look at this language in the next section that says that this right shall not be directly or indirectly denied, burdened, or infringed. And so it's important to know that this is broad language. This is really vague of what does it mean to deny, burden, or infringe this, because denial, burdenment, and infringement of care will really probably affect doctors having protections of conscience rights. And that's really important, that it can be considered that you're denying someone a fundamental right if you're a doctor that says, I have an ethical concern with performing this abortion, I have a moral or religious concern and I don't want to. The argument now is that under this law, you actually have a legal obligation to, because that's a fundamental right. This can also potentially be excluded even to people who are sidewalk counseling outside of abortion facilities or pregnancy care centers providing alternatives. Because this is so broad, we don't actually know how far it would be carried. It's really vague, and it's like that intentionally because it allows this openness where this will then have to be litigated in the courts. And we've seen in other states with this amendments, the litigation that happens is always in favor of the abortion industry because of the way these amendments are written. And so we're going to see doctors lose conscience protections, and we could possibly see sidewalk counselors and pregnancy care centers and other groups that are considered to burden or infringe upon this right be affected in the work that they're doing. The other thing we see here is this term compelling state interest, and it's important that we understand what this means because it appears a couple of times in this amendment. Compelling state interest is the government's what the government is interested in, their interest, and what they're able to protect a law or pass a law on. And so, in order for the government to pass a law, they have to have a compelling interest. And so, the way that compelling state interest is defined in this amendment is that the only compelling state interest is the interest of the mother to receive an abortion, not the life of the preborn child, and not even doctors or other parties that might be involved with this. And so, even a mother who maybe her compelling interest is that she wants to sue because of medical malpractice, that's not covered in this. It's only the interest of a woman seeking abortion care. And so, it is a really narrow definition of what compelling state interest is. And it also follows up with achieved by the least restrictive means. So, even if there is something that's judged to be a compelling state interest, it has to be done in the least restrictive way possible, even when that's not necessarily the most beneficial thing.
So we also want to take a look at here where it says that the Commonwealth may regulate the provision of abortion care in the third trimester. So what we already know is that we are allowed to have abortions as needed, but you need the approval of 3 physicians. So this would reduce the need for 3 physicians down to 1 physician, which would just be the abortionist in order to provide that abortion later in the pregnancy. We also know that it is based on the professional judgment to protect the life or the physical or mental health of the pregnant individual. So this could mean that any physical or any mental reason would be the reason why a woman would seek an abortion. So if she just is saying, hey, I'm depressed, no matter how far along she's in the pregnancy, that could justify the need for her to receive those services. And then when we also look at the last part here, it says the professional judgment of a physician that the fetus is not viable. So what this would mean is that any baby that is born alive, usually, and it does happen in later abortions, there might not be provision of life-sustaining measures for those infants that are born alive. And this is a concern for a lot of people because even people that are normally pro-choice, they do not really support later abortions. And if babies were born alive, they would still believe that that baby has a right to be kept alive or protected.
And I will add too, when we see this language of physical or mental health, this is a much lower standard than current Virginia law, which says that there must be irreparable harm done to the physical health or life of the pregnant individual. And so that's a hugely different standard because now this is just any physical or mental health concern. And every pregnancy, even if it's a healthy pregnancy, does have physical and mental health impacts. And so again, this is really vague language that's done in a way that opens it up to abortion up until the 9th month of pregnancy without restrictions.
Yeah, we've seen abortionists, abortion providers say that every abortion they perform is medically indicated. And so that's the language here. When you hear medically indicated, typically what you think they're saying is something like an extreme health risk to the mother or a horrific fetal anormality. That's the language that they try to use to justify, especially later abortions. But you can see abortionists saying they're all medically indicated because, like Thomas said, pregnancy is a medical condition that impacts your health in one way or another. And so this language is very, very broad. And like Thomas said earlier, this isn't our conjecture about what could happen. This is based on what courts have ruled amendments with the same or very similar language mean in practice in other states. You can look at those states that have passed similar ballot initiatives and see the status of abortion there. And there's no reason to think that those rulings won't be the same in Virginia.
We also want to talk about this language here that says protection or enforcement of the fundamental right. And it says the Commonwealth shall not discriminate in the protection or enforcement of this fundamental right. Again, we want to this really illustrates how broad and vague the language in this amendment is, because the only protection or enforcement of the fundamental right means in favor of the abortion industry. And again, in favor of a person seeking an abortion. That means there is no interest in someone seeking who's seeking help if they were the result of medical malpractice and an abortion went wrong, if it is in the interest of a preborn child, of a family member, of someone who maybe was coerced or sex trafficked into this abortion. There's no recourse for them because the only protection or enforcement of this fundamental right can be in favor of the abortion industry, in favor of protecting someone seeking an abortion. And so we really should be concerned about how broad and vague this language is. And if this is really about upholding Virginia's current law, then they could use a lot more specific language. And the Virginia Code has very specific language about how abortion law is to be enforced. And instead, this would replace it with much broader, vaguer language that would require a lot of litigation in the courts to be worked out. And like Herb said, we've seen in other states with similar amendments exactly how that has played out. And it is to expand abortion access with no restrictions at all.
We also want to take a look at about how this language is very concerning when it says the Commonwealth shall not penalize, prosecute, or otherwise take adverse action against an individual. So when we're thinking about this, that anyone that might receive an abortion, whether they're coerced by traffickers, abusers, pedophiles, there won't be any examination. There won't be any further investigation about why this abortion is being perceived, because we can't look into that, right? We have to enforce and allow this right to be taking place. It also will open the door for if there's any gross negligence or medical malpractice or misconduct with the abortion facilities. They'll be seen as, well, we can't look into, healthcare standards or checking in to see if they're violating anything that might put the women at risk in these clinics, because those safety code regulations, anything that's regulatory, could be seen as we're taking an adverse action or we're impeding on their fundamental right. And then
I'll also add here that this language is particularly concerning because we'll talk more about what current Virginia law is later, but at this point, that is already the case. It sounds as if it's just speaking about a woman seeking an abortion. Mm-hmm. Right now in Virginia and in every other state, women are not able to be prosecuted for seeking an abortion. That is the case in Virginia now. And so changing the law will not happen as a result of this amendment. And I think that it's really concerning that they have this language in here, I think, in order to scare people about what the current laws are. There's a lot of fear mongering, but there have been no indications that anyone is trying to criminalize women who seek abortions under current Virginia law. And it's worth pointing out that this language is concerning for that reason. And it frustrates me that they feel as though they have to say, we will not be able to penalize a person for seeking an abortion, when that's already the case in every state.
And I would add too, I think the other important thing is, right, we're talking about sex trafficking, abuse, coercion. There is this language at the end that says with such individuals voluntary consent. And the important thing to note is, though it says that in this amendment, there's no definition for what that means. There's no definition for how that has to be provided. And again, that leaves up to interpretation. So that can be, well, they did give me their consent verbally, and that can be easily faked. They can easily fake documents showing voluntary consent. There's a lot that can be done, and we see this happen all the time, even in states with stronger laws protecting women seeking abortions, that there are a lot of times where that consent is forged or it's made under duress, and it's really difficult to prove that. And so again, this is really going to protect sex traffickers, abusers, and prevent us from looking into these cases in any meaningful way. All right. We also want to, in this part, talk about what does it mean a state interest is compelling only if it is for the limited purpose of maintaining or improving the health of an individual seeking care. As we kind of talked about earlier, what a compelling state interest is, this gives it a really narrow definition. It's interesting in this amendment, this is one of the only specific definitions that we're given, and that's intentional, because that means that a state interest is compelling only if it is going to maintain or improve the health of an individual seeking care, meaning the person seeking the abortion. So any sort of involvement that the state can have when it comes to abortion has to be maintaining or improving their health. And so again, that makes it really difficult to say if they already received the abortion and now they're seeking medical malpractice afterwards, they're no longer really seeking abortion care as defined in this document. So can the state get involved? Probably not. And that would have to go to court. What about if we need to pass a law concerning infants born alive? Can that be done? No, because that's not in the compelling state interest. What about health and safety standards? Well, who sets those health and safety standards? Is that a limited purpose? What does that mean? And so, again, this is going to be very narrow and restrictive on any sort of even the most bare minimum regulations that could be passed.
I also want to add as well that when we think about people that might be impeding or seen as impeding upon this fundamental right, this would violate doctors and medical professionals going against their medical conscience. So it'd be penalizing a lot of the people that would say, hey, let's put a pause on these, abortion standards, or let's think about, do we really want to do this or participate in this practice? And it might be more of a direct attack on those situations than the people that are actually coercing or enforcing abortion practices that really will damage the mothers and communities.
Yeah, and then the last part to look at, the very last line of this amendment, is this phrase does not infringe on that individual's autonomous decision making. And we see that that is, kind of highly introduced in here, that whatever the state's compelling interest is, it cannot infringe on that individual's autonomous decision making. And that phrase of individual's autonomous decision making means that essentially it doesn't really matter what the state's compelling interest is. If that individual says this was my decision or this was something that I wanted, and whether that's true or not, whether they were coerced, whether they're being forced under duress to say that, if they say that it was their decision or that it infringes on their ability even to make a decision about abortion, then the state can't get involved. There can be no laws or regulations or investigations had. And so that is very strong language, and that is very vague language that, again, we see this consistent theme throughout the amendment language, that it's broad, it's vague, and that is the purpose. The purpose is that this is really vague and it can be interpreted by the courts in favor primarily of the abortion industry. Okay, so next we're going to move into, that is the constitutional amendment. That is what will go into Virginia law. We also want to talk about what it will look like on the ballot, because when you go to vote, you won't get to read this whole amendment. You'll get to read a ballot question that says, do you support this? And what the ballot question is it's misleading, and it doesn't reflect everything we just learned, everything we just talked about. The ballot question doesn't accurately reflect that at all. And so let's dive into what this ballot question looks like. So the ballot question has 3 parts. We're going to show those 3 parts on 3 different slides. And the ballot question will appear as follows. It'll say, should the Virginia Constitution be amended to include the following? And then it will have the 3 points after it. The first point is the freedom to make decisions about prenatal care, childbirth, postpartum care, birth control, abortion, miscarriage management, and fertility care. So again, we see how they slip abortion right there in the middle towards the end, and they show all these other things that really are great: prenatal care, childbirth, postpartum care, fertility care, miscarriage management. These are all great things that we do want to protect. But again, they've slid abortion in there, that controversial thing, right in the middle, to hide it and to make it so people don't understand that what they're voting for here is unrestricted abortion.
The second part, that this amendment will protect doctors, nurses, and patients from being punished for these decisions. So again, they kind of want to use this language to say that anyone that's performing these abortions, they can be protected, they're not doing anything wrong. But it does not indicate, like we mentioned earlier, that medical professionals that might be against this or might have their conscience being pressed, they might be punished for not enforcing this right or this law.
Yeah, and then we see point 3, allow for restrictions on access to abortion during the 3rd trimester of pregnancy, except when the patient's health is at risk or the pregnancy cannot survive. So this is designed to make it appear as though that 3rd trimester, there'll still be restrictions. We'll uphold current Virginia law. It's only for medical emergencies. But as we saw in the amendment, that's not true. It's not just upholding current law, and it's not actually doing what this ballot question says it is. So it's important to remember that.
And just to reinforce again that this will allow abortion through all 3 trimesters for any really medical reason that's in the interest of the mother only, and it will reduce the number of doctors that are needed from 3 to 1. So we just wanted to think about when some of these polls that you might go and vote at, unfortunately, they may not even have the amendment written out, and they may not even have the ballot question. So we want to reinforce you that you know what this ballot question is, because they might just say, do you agree to vote yes on, number 1? And we really want to make sure that we emphasize that so that you know what you are voting on.
Yeah, and so what are the key takeaways from this video? We want you to remember that the amendment has broad, vague language that is far more extreme than current Virginia law, and that the ballot question is meant to mislead and misdirect voters about what the amendment will do. So those are the 2 key points you need to know about the amendment language and the ballot question language. This is what you need to remember and convey to people.